I'll tell you a little bit of something about myself, and I put this in a PDF form as opposed to a PowerPoint form, so I'll scroll down. I'm a professor at Middle Tennessee State University. I do work primarily on race and politics, and I've done some work with a number of voting rights organizations such as the NAACP LDF, the Lawyers Committee for Civil Rights, the Southern Poverty Law Center, Southern Coalition for Social Justice. These are the groups that I've done some work with in terms of assisting on voting rights disputes. And there you can see also some of my publications. What I'll do is I'll give an overview of the Voting Rights Act and really voter justice issues in general. We'll talk about the federal voting rights infrastructure, ongoing concerns of voting rights. We'll highlight a few examples regarding voting rights, and then we'll look at where do we go from here. And so this presentation is prepared to go as little as 10 minutes, but can also go as long as 40 or 45 minutes. I just didn't know how much time I was going to have, so I prepared for both, if that makes any sense. I want to say to you, please, if you want to interrupt me and ask any questions, please do. I have this in the PowerPoint version, and I don't think I'm able to see at the same time. I haven't figured out how I can see an answer on a question on the screen, on the chat room, as well as my presentation all at the same time. So I'll be pausing periodically just to double check to see if you have any questions or comments, if that makes any sense. Okay. So let's look at the Voting Rights Act. So many of you have heard of this thing called the Voting Rights Act that people like John Lewis and other folks have kind of fought for historically. I'll just give you a broad overview of voting rights, but I do want to emphasize this point that although we had a monumental Voting Rights Act that was passed in 1965, it was not the first voting rights bill. The collection of voting rights bills that preceded this occurred during Reconstruction, primarily in the 1860s and 1870s. And then even before 1965, there were some minor, though I think very important changes at the federal level when it came to voting rights interrogation that were done in the Justice Department. So I'm describing what most Americans know as a Voting Rights Act in the next few minutes, but I do want to emphasize that the voting rights claims, voting rights interrogation, dates back 100 years earlier. So the Voting Rights Act of 1965 is the monumental piece of legislation that protects and guards voting rights in this country. It was a flagship legislation that was born of major protests in the street and in rural communities, culminating in a series of local campaigns, Selma, Alabama being the campaign that many Americans know the most. The Voting Rights Act does a large number of things, a litany of things. For the purposes of this discussion today, and for your purposes with the voting rights, and for today's discussion, what the Voting Rights Act does is that it outlaws discriminatory practices at the polling booth, and that may mean moving polling places, violent intimidation, but it can also be issues such as today, photo ID laws, voter purges, not counting votes properly. It could mean a whole range of things that have seemingly overt discrimination, but also in many respects, less overt forms of discrimination. And then the Voting Rights Act of 65 also created what's called the pre-clearance provision, in which if you come through the NAACP, or if you come through any major civil rights groups, you'll probably know what this means. This meant that if you came from a certain part of the country that historically had practices of discrimination that were so profound that if you made any changes to your voting rights, if you made any changes to your election practices or procedures after 1965, those changes had to be approved by the federal government, the Justice Department in particular, or the federal courts. So let's just take an example. If you're in the Mississippi Delta in a town in 1960, you can go to Greenwood, Mississippi, a town that was 90% Black, 95% Black, and they had the worst voting rights abuses possibly in the state, if not in the country. Blacks were not allowed to vote. Well, when the Voting Rights Act was passed, one could assume that those individuals were going to be allowed to vote, but state lawmakers, state officials who were still controlled by the Jim Crow regime, or who still were essentially pushing the Jim Crow racial segregation regime, we're going to obviously find a way to dilute or hurt the Black vote. And one way they tried to do this was to pass laws after 1965 to do this. So what the civil rights activists did and what the voting rights activists did was they built a framework inside of the Voting Rights Act of 65 that said that if you came from the worst offending states and jurisdictions and counties, if you made any change to your election practices and procedures, we have to know that those changes will not harm African Americans or Native Americans, right? And so those changes had to be approved and what's called pre-cleared or cleared by the Justice Department or by the federal government. Again, answer any questions if you have any, please, by all means. So that's what the Voting Rights Act ultimately did. It was a flagship piece of legislation. And then it was extended or expanded in 1970. In 1970, they renewed the Voting Rights Act because when the Voting Rights Act was passed initially, it was only set for 5 years. So they renewed it in 1970. And this time they added young people, 18 to 20-year-olds. Because of some disputes about the law and federal and state jurisdiction, right? That part of that expansion of voting rights to young people had to be ratified or had to be approved by a constitutional amendment called the 26th Amendment. And this mattered because young people in 1970 were dying in Vietnam, were protesting in the streets, but if you're 18 or 19, you couldn't vote. So what the Voting Rights Act did ultimately was expand that. Later that was codified by the 26th Amendment. Now here's the other thing was that in 1975, the Voting Rights Act was renewed again. And this time they extended protections to Native Americans, Latinx individuals, anyone who did not speak English as a first language. So that could be Yiddish Americans in New York, and maybe Chinese Americans in San Francisco, in Chinatown, or Chinese Americans in New York, or it could be Latinx individuals who were in Texas and Arizona and parts of California, or people who are native country. And native country mattered a lot because in many parts of so-called American Indian country, individuals spoke their indigenous language as their first language. So what the Voting Rights Act of 675 did was it extended those protections to non-English speakers effectively. And then the Voting Rights Act was extended in 82. And in 1982, what the Voting Rights Act did in a nutshell was they added more provisions in the Voting Rights Act that could deal with what's called voter dilution or institutional discrimination, even if it was very hard to demonstrate that discrimination existed through a smoking gun. So the best way to describe this would be that what the 82 Voting Rights Act did was that, thank you, it gave essentially voter protections to individuals who face discrimination that was institutional or systemic, so to speak. Okay. And then we saw other provisions, if that makes any sense, with the Voting Rights Act. We saw in 1993 the Motor Voter Act was passed, and Motor Voter Act basically allowed for voter registration to occur at Department of Motor Vehicles agencies and at state and local agencies that are offering public assistance. And that's oftentimes not enforced, but that does exist in the voting rights laws. And then in 2006, what the Voting Rights Act did, it was extended again. And it was extended to, again, for another 25 years or so, for essentially a long period of time. And this time, what the Voting Rights Act of 2006 did was it attempted to correct attacks that were made to the Voting Rights Act by the federal courts. I'm going to check my chat session. Yeah. Okay. What is an example of institutional discrimination? Actually, I have an example right here. I think I have an example. I do not have an example. Well, let's take, for example, you have one side of town. I see your question, Ms. Perkins. Let's say, for example, you have one side of town, and this really did exist in Native country, in which 90% of the people don't have running water, in which 90% of the people don't have electricity. in which you can't even set up a polling booth in that particular side of town because effectively the majority of facilities don't have electricity. Historically, those parts of town, those communities historically had the worst services when it came to polling sites. They had the worst services when it came to election assistance. They had the worst services when it came to information about voting, right? So what the Voting Rights Act of 1982 effectively did was it included provisions that said that if you come from those kinds of communities and there's overwhelming evidence that those kind of communities somehow, some way also have the lowest voter turnouts, also have the fewest amount of services when it comes to election assistance, that will be an example of institutional discrimination. If that makes any sense. I'll give you another example that occurred that was quite common. In some communities, you may elect a county executive in parts of the South. So from the 1800s to 1964, or from the 1800s to 1980, if you wanted to elect an executive or a mayor from a county, if you want the county mayor or executive, you would elect that person. Well, lo and behold, when the Voting Rights Act was passed, all of a sudden the state legislature, which was controlled by people who were empathetic or sympathetic to Jim Crow, mandated that the only way that that person in a county could serve as mayor or executive is if they were appointed. They had to be appointed by the Board of Supervisors, or they had to be appointed by the state legislatures. So now that was not an example of what's called bull Connor racism, where someone's standing at the courthouse threatening someone from voting with a gun. But that was an example of an institutional form of discrimination that had the same impact or same effect as diluting or harming one's ability to elect a candidate of their preferred choice. So there's just dozens of different ways in which you can limit one's right to vote, even if there's not a quote unquote smoking gun, or even if there's not quote unquote bull Connor racism. I'm going to get to your question, Mr. Williams, next, actually, Chuck Williams. So yes, in 2013, the Supreme Court approved of a court case called Shelby County versus Holder. Shelby County was Shelby County, Alabama, not Shelby County out of Tennessee. And in this case, what Shelby County versus Holder effectively did was that case essentially overturned or eliminated this right here, the pre-clearance provision of the Voting Rights Act. The pre-clearance provision was considered to be the holy grail of the Voting Rights Act. So if you came from Alabama or Mississippi, if you made a change to your election procedures, those changes had to be approved and pre-cleared by the federal government. Now that no longer exists because of the Shelby County versus Holder case. And basically, to Mr. Williams's question, what the Supreme Court effectively stated was that you are discriminating against those states, mainly in the South, that have historic practices of discrimination. Number two, the court said that the pre-clearance provision is out of date. The pre-clearance provision was adopted in 1965, and here we are in the 21st century, and it's out of date. But that was those were the constitutional arguments that the Supreme Court made. In reality, anyone who's dealt with voting rights knows that conservative jurisprudence, that is, those individuals who have historically been against voting rights claims, wanted to eliminate pre-clearance. And ultimately, they shopped that case around, to Mr. Williams' question. What I mean by that is that attorneys that wanted to attack voting rights claims shopped disputes around. That is, they found plaintiffs that they could constantly bring cases against in order to undermine the pre-clearance provision, and they found a jurisdiction that met their satisfaction, which was Shelby County, Alabama. And so since Shelby County, Alabama was passed, we've seen a wave of attacks against voting rights, primarily in the South. We've seen the imposition of photo identification laws. Between 2013 and 2016, after the Shelby County was passed, 850 polling sites closed, most of which occurred in pre-clearance jurisdictions. So we've seen a wave of attacks occur primarily in those jurisdictions when it comes to voting rights claims. You should be able to see this map right here, and this map displays or shows those particular areas that were under pre-clearance. And you can see right here, we had Texas, we had Louisiana, we had Alabama, Mississippi, parts of Florida, parts of North Carolina. We also had parts of Native country. We had a broad swath of the country that was under, particularly in the South, under what's called pre-clearance, and parts of other states that were under pre-clearance. So what that means is that if you came from a state in which parts of the state were considered to be okay and other parts considered to be bad, those bad parts were considered to be under pre-clearance. Okay. Before I move on, I do want to revisit Mr. Williams's question. Is that so? Shelby County was passed, was adopted, whether it was approved by the courts. So what the voting rights community did was to what? Pass a new voting rights bill, or at least propose a new voting rights bill. And one of the bills has been adopted and approved by the House. It's sitting right there in the Senate. And what that new voting rights bill will do, and this is why the election today is important, is that what that new voting rights bill will do is that new voting rights bill revises and updates the pre-clearance provision to satisfy the Supreme Court's litmus test. And if adopted, then the Voting Rights Act will be restored, hopefully at its fullest reach, with a new pre-clearance provision. But we just can't get members in the Senate to even bring the voting rights bill that's been approved by the House up for a vote. So that's where we are today. But here's the other thing, folks. When it comes to voting rights claims, we also have an infrastructure, right? And I'm hoping that you can see this entire slide right here. So this is the Justice Department, right? If you see right here, there's something called the voting section in the Justice Department that exists, okay? And that voting rights section in the Justice Department that exists monitors voting rights claims. Now, today in 2020, that voting section is for the most part dormant, asleep, ineffective. It's effectively been so watered down that it's ineffective, right? So even though this voting section comes out of the movement, the civil rights movement, as we call it, right? Today in 2020, it's for the most part dormant and ineffective because of the current occupant in the White House, if you want to be quite frank with me about that. Okay. So it's also important to point out that we do have a consortium of voting rights and civil rights groups that exist, and they operate at all levels. But this is an example of all the groups, and there are more, that are involved in voting rights litigation. And so they're the ones that are enforcing and monitoring the Voting Rights Act today. So you got the LDF, you got the NAACP, the Lawyers Committee, ACLU, and they're bringing real cases. I mean, you can see right here, these are all the jurisdictions in which they are actually bringing real cases. Okay. And you can see right here, this is just another example of the various cases and claims today in 2020, voting rights claims that are being brought today by these various groups. Just a snapshot. I think last I checked, there may be over 100 different voting rights and election protection claims that are being brought by voting rights groups today. And these are just the national groups. There's also a number of local law firms, right? So you have the Lawyers Committee for Civil Rights, Campaign Legal Center, the NAACP LDF, the Southern Poverty Law Center has a new voting section. The Southern Coalition for Social Justice, anyone out of North Carolina, has assisted in the voting rights claim, the NAACP versus McCrory, that made its way up to the Supreme Court several years ago and won. The Brennan Center, the Advancement Project. So we have people on the ground that are fighting real issues when it comes to voting rights today. Okay. So let's look at some contemporary challenges, because I know it's 11:42, and I think this session ends at maybe about 12 o'clock. So I do want to leave room for questions and answers. And if there are no questions and answers, I'll just finish off what I didn't cover. So these are some of the contemporary challenges. Again, I just want to give you some insight on this. So for example, one of the major challenges is to photo identification laws. And you can see a number of states have passed photo identification laws. Since interestingly enough, most of which occurred after Obama's election. And some of them have strict voter ID laws, some of them have loose voter ID laws. Now, you may ask the question, why do we have voter ID laws and why does it matter? The theory behind the photo ID law, if you wanted to have a sympathetic reading of the photo ID laws, is that you needed a more uniform process, particularly after the fiasco of the 2000 election. And there's a long kind of historical kind of analysis that I can give about that, but I'm going to kind of gloss over that. But you can see right here, based on some of the data that we've seen, this is who's been impacted by photo ID laws. So 11% of voting age citizens did not have a government issued ID. And this data is several years old, but it's still, for the most part, relevant. In some places, it's 25% of African Americans, 18% of seniors, 50% of low income residents. And what this is basically explaining is that these individuals have photo IDs, but they don't have the kind of qualifiable type of photo ID law that is required to actually vote. There's a geographic bias because in the South, we are hit the hardest. I'm in Tennessee, if you're in the South. 32 states have identification requirements. A number of states have strict requirements. In particular, Texas and North Carolina have had the strictest requirements, and those are the requirements that have been essentially adjudicated in the courts. That means the courts have been somewhat sympathetic towards voting rights attorneys. Pennsylvania also had a very strict photo ID law that was passed about 8 or 9 years ago, and it was overturned not by the federal courts, but overturned by the state courts. So what you found was after the 2008 election was that a wave of photo ID laws were passed, and those of us who are into the voting rights issue know the reasons why in terms of who was being targeted. And so you may say, well, why does this matter? Let's look at Alabama. If Alabama mandates that you have to have a government issued ID, most of those IDs are issued at the DMVs, Department of Motor Vehicles. But Alabama closed 31 DMVs several years ago, right? And where do they occur? If you have any familiarity with Alabama, where do they occur? They occurred mostly in the Alabama Black Belt, the places where African Americans overwhelmingly reside, right? So the overwhelming majority of DMVs closed in this particular region of the country, of the Alabama, that essentially impacted at least 250,000 people of voting age. I do want to emphasize the point that the General Accounting Office also produced a report on photo IDs. And it's a very revealing report. In the state of Tennessee, as an example, as much as 3.1% of African Americans were affected adversely by the photo ID laws. Now, you may say that doesn't matter, but it does matter. In a presidential voting election year, that could amount to tens of thousands of voters, right? And maybe it doesn't impact the national presidential election for a state like Tennessee, but think about the spillover effect or the down ballot voting for local elections that it may impact. So these things do matter when it comes to voter restrictions. A lot of states also, particularly in Native American country, also mandate that not only do you have to have a photo ID, but the photo ID has to match your residence. Now, why does this matter for Native Americans? Because a lot of Native Americans, their residence is a reservation, a federal reservation approved by a treaty and approved by the federal government. Well, what a lot of states begin to do in Native country, or some of the states begin to do, was to say, look, your photo ID law has to match the county that you're in, not your tribal identification. So they even went much further in mandating that you can only have a photo ID that essentially was different from your tribal or reservation ID that was approved by the federal government. So these are examples of discrimination, often institutional discrimination, that are affecting voters today that we have to be very mindful about. You also have an example, what's called vote caging. I'm going to kind of scroll through this pretty quickly. Vote caging occurs when political operatives identify a geographic area with a high number of people who belong to another party. Those operatives will contact those individuals, often through first-class letters, to see if they live there, asking them to respond. If they fail to respond, or if the letters are returned, those individuals can be placed on what's called a caging list, right? And operatives can match those individuals with election precinct data, and then they'll often show up to election precincts to challenge these voters. Now, if they challenge these voters, they can't challenge them directly through intimidation, overt intimidation, but they can challenge the poll workers and tell the poll workers that these individuals may not be qualified to vote. This is a practice that dates back to the 1960s. It accelerated somewhere around 2006, 2007, particularly targeting Blacks, Latinos, and HBCU students, right? We didn't see it as much in 2016, but there's a strong possibility we'll see it in November. And in the case of the president has said that he will essentially encourage sheriffs, law enforcement officials, to be frontline officials when it comes to vote caging, which is extraordinarily dangerous, because the only time that we've seen that occur was in the 60s, in which people like Bull Connor and others were frontline operatives when it comes to vote caging. But vote caging is real. Vote caging is real. It wasn't widely used as much in 2016, but it occurred a lot in 2006, and we can expect that it will occur again in November. So then you also have the issue of voter purge. This is the most problematic issue that we find when it comes to voting rights claims, because a lot of voters are purged from the voting rolls, even though they're eligible. Some states time purges 90 days before the election. Some states will purge voters based upon what's called a no match ID, a no match, no vote provision. That means that if your name is John Smith, right, and a person is registered as John L. Smith, right, they'll compare the voter ID with the actual name, and they can actually erase or eliminate or purge a voter from the voter roll. In the case of Georgia, they just purged literally 309,000 voters in December. So voter purges are extraordinarily wide, and it can be extraordinarily abusive. You're not supposed to purge the voters unless they are dead, they have moved, they may be ineligible, maybe due to incarceration. Some states have provisions in place that says that you can only vote if you voted in the last two quote unquote November elections, and if not, you could be purged. But voter purge is so widespread and abusive, and a lot of eligible voters have been purged from the voter rolls in the last 10 years. It's prone to an enormous amount of errors, and in this case, that photo that you see in that slide is a woman who was eligible to vote in Tennessee, but was purged from the voter roll theoretically by mistake. Anybody have any questions or comments? I'm going to fast forward to something that's important, and I'm going to abbreviate the presentation and just ask for questions or comments. I'm going to try to finish this in the next 4 minutes, and I believe we'll leave the last 5 minutes to any questions or answers. So now, today, a wave of voting rights groups are pushing for vote by mail because of COVID-19. And the big thing that really got them was this slide right here in Wisconsin, in which the Wisconsin Supreme Court, backed by the U.S. Supreme Court, refused to extend the election by a few weeks so that more people can do absentee balloting or vote by mail. And then as a consequence, on election day, large numbers of people had to vote by mail, on top of the fact that in the state of Wisconsin, they shut down and closed a number of election precincts, a number of polling locations. And as a consequence of that, a number of people got sick on election day. It was a pretty horrifying outcome that occurred at that particular time. So a number of people are pushing for vote by mail as a way to mediate that issue and to mitigate the idea of people getting sick on election day. And there's a number of studies that show why we have to be concerned about the intersection between public health and voting. That in those particular places across the world, those countries that have poor public health tend to have weak voter participation. So every single civil rights organization is involved in essentially a vote by mail litigation. That is a way to expand vote by mail to people including those individuals who are not sick because of COVID-19, but those people who are from communities that are more vulnerable to getting sick. And this matters to us because Black, Latinx, and Native Americans have essentially experienced the highest rates of COVID-19 infections. So I'm working on a case in Louisiana, on a vote by mail case that has been bandied about in the federal court down there in Louisiana. And this mattered because 70% of people in Louisiana who were COVID-19 positive as of April and May were African Americans. And as you can see right here on this slide right here, based upon data that we received from the American Community Survey and other data points, we can see that those communities that had higher numbers of African Americans tended to have worse health outcomes. Those communities that had the highest numbers of non-whites right here also had worse health outcomes. So this may be hard to interpret in 30 seconds or so, but what this data shows is that there's a relationship between racial composition of the county and health outcomes. There's a relationship between racial composition and vulnerability to get COVID-19. So the idea that someone could vote by mail in order to reduce the possibility of getting sick on election day matters a great deal to voting rights advocates in this country. And so this is another example of why voting rights today is much more expansive than it was even in 1965. We're looking at issues of public health. We're looking at issues of photo ID. We're looking at issues of voter purge. We're looking at issues of vote caging, and we see other examples of intimidation that I can go through. Redistricting, which will be an issue that essentially we have to deal with after the election, in which redistricting, drawing fair and representative districts are extraordinarily important in order to satisfy not only the Voting Rights Act, but also 14th Amendment claims, particularly the one person, one vote principle of the Constitution as well. So I'm gonna shut down the presentation right here because I think we have 5 minutes, and see if anybody has any questions or comments that I can answer. And I know that was kind of fast. You can ask comments, ask questions, provide comments in the chat room, or you can ask them just verbally. Questions, comments? Yes, Mr. Williams. Yes, absolutely, 100%. Yes, I do some work on redistricting, quite a bit of work, and yes, and if I could pull up this slide right here, yes, you can advocate for your own congressional legislative districts, and what you find a lot of groups doing is doing what's called a community redistricting project. Southern Echo out of Mississippi, the Southern Coalition for Social Justice out of North Carolina perfected this. And this is the timeline when it comes to redistricting that you have to be very mindful about. The timeline is that there's a census, as you could know. The census is going to probably be delayed by 6 or 7 months. They think it's going to come out now in August. And there's a possibility that the census could be somewhat abbreviated, that is undercounted because of what's going on at the federal level. But once the census is produced, most states will have a process in place in which in about 40 to 45 states, the state legislatures will be responsible for drawing congressional districts and state legislative districts. And at the county level and at the city level, that process is going to be under the jurisdiction of the city council, county commission, and or planning agency, planning department. Do not leave it up to the lawmakers themselves to draw districts without your input. If you can, ask for hearings. If you can, pull together a coalition of organizations. If you want to know more about them, I know who they are. I know who to work with. And you can draw your own districts. And you can propose those districts to the state legislatures, to the Black caucuses. You can ask for committee hearings, ask for committee meetings. You can propose them to the local county commissions. Pull together a local coalition. I do a lot of work on this. Please contact me afterwards. And this is the reason why. Let's say, for example, your coalition submits a plan or proposes a plan to the state legislature. let's say the state legislature takes that plan and throws it in the trash, which they possibly could do. If there's any litigation in which a law firm or a voting rights group comes in and says, you know what, those districts were drawn to undermine communities of interest, right? The state legislature may say, well, we have no input. No one may raise objections. They can reach back into the trash, pull that plan out, and say, this is what the community wanted. So please fundamentally advocate for a plan. At the federal level, as much as $600 million will flow to the states and localities and to the congressional districts that will be, in other words, the population, the way those districts are drawn are going to shape how $600 million are going to flow to those districts. Maybe as much as $1 billion, according to some analysts. So by all means, please get involved in this particular process. I'm going to put down my information right here. I want to emphasize that point that Mr. Williams and others stated, that I do work with the Lawyers Committee on Civil Rights. They have a very good person there who's involved in. I know the folks at the NAACP LDF, Lee Aiden. Southern Coalition for Social Justice has some very good folks. They have a community redistricting project right now, the Southern Coalition for Social Justice. So please, by all means, get involved in this, because once the election happens, the redistricting process is starting. And the people who want to draw districts that harm communities of interest, right, that want to harm the, marginalized communities, they're going to be accelerating their attacks. They're going to be accelerating their redistricting plans, and they're going to have a lot of money behind them. A lot of money behind them. And remember, redistricting is a voting rights issue. It's a voting rights issue that was affirmed by the 65 Voting Rights Act, that was affirmed by the 65, 70, the 1982 Voting Rights Act that was renewed, dealt fundamentally with redistricting. Furthermore, redistricting is protected, as is voting rights, not just by the Voting Rights Act, but by the 14th Amendment of the Constitution, equal protection, and it's protected by the 15th Amendment, right? So we just need people on a battlefield who are ready to go and fight, not just in this election, but the main battles are going to take place also after the election. So by all means, folks, please contact me if you have any questions. And I thank you for having me and listening to me.